If you're waiting for your green card or planning to file your I-485, you need to hear this. On May 21st, USCIS dropped a bombshell memo that could change everything about your case. They're now saying that getting your green card inside the United States is not a right, it's a privilege. And even if you qualify on paper, they can still say no. I'm Louis Hess, immigration attorney, and in this video, I'm going to break down exactly what this memo says, what it means for you, and the 3 critical things you need to know to protect your case. Here's what happened. On May 21st, 2026, USCIS issued Policy Memorandum PM-602-0199. Now, most people file their I-485 thinking, I meet the requirements, I submitted my paperwork, I paid the fees, so I should get approved, right? Wrong. This memo reminds everyone, including USCIS officers, that adjustment of status, getting your green card from inside the United States, is what they call an extraordinary form of relief. It's an act of administrative grace, not an entitlement. Think about what that means. You could be married to a U.S. citizen. You could have a job offer from a major company. You could have been living here for 20 years, and USCIS can still look at your case and say, we don't think you deserve this. Now, this isn't technically new law. This principle goes back to a 1974 BIA case called Matter of Blas. But what is new is the emphasis USCIS is placing on it right now. They're telling their officers to apply heightened scrutiny. They want officers to really examine whether you deserve the privilege of adjusting status here versus going back to your home country and applying at a consulate. So what exactly will USCIS officers look at? Let me walk you through the key factors. First, immigration compliance history. This is huge. Did you overstay your visa, work without authorization, violate the terms of your parole? All of those count as significant negative factors. If you remained in the U.S. beyond your authorized stay instead of pursuing consular processing abroad, that weighs against you. Second, fraud or misrepresentation. Any false testimony to USCIS or any government agency, even years ago. Third, conduct inconsistent with your visa purpose. If you entered on a tourist visa but immediately started working, or entered on a student visa but never enrolled in classes, USCIS can argue you always intended to stay permanently. Fourth, whether your original admission was lawful under the laws and policies that existed at the time. Here's where it gets complicated. The memo specifically addresses dual intent visa holders like H-1B and L-1 workers. You'd think being in valid status would be enough, right? It's not. The memo explicitly says that maintaining lawful status in a dual intent category is not by itself enough to warrant approval. They can still deny you. The burden of proof is on you to show why you deserve a favorable exercise of discretion. Let me give you 3 key insights. Number 1, document everything positive about your case. This memo creates a balancing test, positive factors versus negative factors. Family ties, document them. Community involvement, get letters. Job stability, tax payments, property ownership, prove it all. The absence of negative factors alone is not enough. You need to affirmatively show unusual or outstanding equities. Key insight number 2, get ahead of any problems now. If you have immigration violations in your past, if you worked without authorization, if there's any fraud or misrepresentation in your history, do not assume USCIS won't find out. Under this memo, any of those issues can sink your case. An experienced immigration attorney can help you address these issues proactively. Deal with it before USCIS makes a decision. Key insight number 3, consider your alternatives. This memo signals that USCIS may push more people toward consular processing, meaning leaving the U.S. and getting your immigrant visa abroad. For some people, that might make sense. For others with unlawful presence bars, that could be catastrophic. This is why you need individualized legal advice. So here's your action step. If you have a pending I-485 or you're planning to file one, you need to review your case in light of this new guidance. Understand your positive and negative factors and get a strategy. At Prosperity Immigration Law, this is what we do every day. We fight for families, we fight for workers, and we fight for people who want to build their lives in this country. Call us at 2-817-299-9433. Link is in the description. We offer consultations specifically designed to evaluate your case under these new USCIS policies. Don't wait until you get a denial notice. By then, it's often too late. Act now, and I'll see you in the next video.